An operating agreement is far more than a formality. It's your business's foundation and legal financial rulebook. Giving this keen document attention at the beginning of your entrepreneurial journey can proactively mitigate significant headaches and costly legal battles down the road. Whether your new business is a single member LLC, a partnership, or an LLC that's elected S-Corp status, a well-written, comprehensive operating agreement is essential to the longevity and stability of your enterprise. Why are operating agreements essential? Oh, by the way, welcome to Ed Talk Today and our series on starting your own business and charting the course for your life. Why are these agreements essential? They're not just a formality. There are two primary and compelling reasons. One is conflict prevention. The agreement forces you to anticipate, discuss, and resolve potential issues before they emerge and turn contentious. Second, legal and financial protection. In most cases, they're a practical necessity and they're often required by law. A single member LLC, for instance, frequently needs a formalized operating agreement just to open a business bank account in the company's name. More importantly, without a proper operating agreement, you risk invalidating your limited liability protection and potentially affecting your tax status. Consider a simple partnership. The most basic decision is how to split the profits. But a robust operating agreement requires you to think far beyond that initial consensus when drafting this all-important agreement. This discussion offers essential food for thought when preparing your operating agreement, whether you're forming a partnership, a simple single-member LLC, or an LLC that's opted for S-Corp status for tax purposes. Let's get into the weeds. Beyond the boilerplate. Your operating agreement is not boilerplate, should not be boilerplate. This is the time to establish clear operational rules and define agreements before unexpected circumstances force the issue. Let's use an example. You and a longtime business associate you like and trust have just established a 50-50 partnership. Today it's just the two of you, but at some point you may want to bring on a third key employee into ownership. Who decides that? If you have a 50-50 vote on all matters, a potential stalemate on this critical decision, or any other, could be a recipe for disaster. How much equity would be available for the new person? What will their voting rights be? How will future earnings be allocated to new partners down the road? These are fundamental questions, which I assume you've already thought of. But have you anticipated these other critical scenarios and memorialized them in your agreement? How about management and decision making? Voting power. Clearly define who holds what voting power, especially if members have unequal ownership percentages. Absent any agreement to the contrary, state law may default to one vote per member in some jurisdictions, regardless of differing financial stakes. It could be a 90-10, but you each get one vote. Think about that. The idea is to clarify all of these things in your operating agreement. How about decision-making authority? Clearly delineate which decisions can be made unilaterally by a manager or a member, and which decisions require a higher approval threshold. For example, a simple majority, a supermajority, or unanimous consent. And management deadlocks. They do occur. Establish a clear, predefined process for resolving solutions where management cannot agree on a critical decision. Solutions like forced mediation or arbitration procedures. And on financial matters, profit and loss distribution. Explicitly define how profits and losses are to be allocated. Partnerships in particular often have flexibility here. For example, although a partnership capital may be 50-50, partnership earnings may be distributed 90-10 or 60-40 and so on, provided the operating agreement clearly outlines this method. And compensation. Specify different forms of compensation, including in S-Corps W-2 wages, bonuses or guaranteed payments in partnerships and distributions, in order to avoid conflicts over what's perceived to be fair pay. Should members who perform extra administrative responsibilities beyond what other partners do be entitled to additional compensation beyond their ownership share? Your agreement should address this. And capital contributions. Address initial capital contributions, of course, but more importantly, define what happens when a business needs additional capital later, sometimes called a capital call. And if some members contribute more or less than others, how does that affect their ownership interest and future distributions? Be specific and lay it out in your operating agreement. It's my suggestion. Anyway. Exit strategies and dissolution. Now, few issues cause more division than the unwinding of a once friendly business relationship. Of course, you got departure, death, incapacity. Your agreement should clearly define what happens when a member leaves, dies, or becomes incapacitated, including how their ownership interest will be handled. In the valuation, company valuation, crucially detail in your agreement how the company will be valued during an exit. Will you use a predefined formula, an agreed upon third-party appraisal, or some other method? And here's one. Buyout provisions. Establish clear mechanisms for buying out a departing member's share to prevent disputes over valuation and payment terms later. One of those things you want to do now instead of trying to do it when it happens. Trust me. Much of this is ignored or glossed over early on because it doesn't seem important when you're starting an adventure and you're going full steam ahead. When these issues arise later, however, they suddenly become the most important issues facing the business. And think about this one. Conflicts of interest. You should outline strict rules for partners transacting business with other entities they own, or, let's say, employing relatives within the business. There's other conflicts of interest, but think about those. I'm sure you can come up with some others. So client ownership. If your business depends on individual relationships, such as professional service firms, what happens if a partner leaves? Can they take their clients with them? Does the firm own all client relationships, or do clients belong to the person who brought them in? What are client transition rules? Can the departing partner solicit them, or be prohibited for a set period of time? Does your agreement need non-competition or non-solicitation clauses? If a departing partner is paid out, does the valuation include a specified value of their client book and its future revenue stream? Lots of questions. Here's another one. Define clear ownership of any intellectual property, patents, trademarks, ideas, even ideas generated by members during their involvement with the company. Now let's talk about that single member LLC, the solo act. Do they need a script? Some might think, do I really need an operating agreement if I'm the only member of my LLC? Well, that answer is unequivocally yes. Not only do banks typically require it to open that essential bank account, because remember, we're not commingling personal funds with business funds, but having a written operating agreement is critical for preserving your limited liability status. And that's the most important reason you formed the LLC in the first place, right? And courts want to see you're treating the business as a separate entity from your personal affairs. It's not a hobby, it's a business. The agreement is where you document your intent, outline capital contributions, define dissolution procedures, and establish how ownership will transfer in the future, maybe on your death, to your will, for example. Bottom line, even if you're going solo, act as a professional and draft an agreement that proves you're serious. Well, future entrepreneurs, that's what I have for you today. Questions, comments, leave them below. Subscribe and select, if you will, all notifications so you'll know when the next video in the series drops. And thanks for watching, and I'll see you next time on Ed Talk Today.